So, returning to our first topic, which is the more general one of the 1980 Hague Convention and the abduction of minors. As I said, I believe that abduction is one of the most delicate issues, if you will, within the scope of private international law. My course is a strictly criminal law course, right? Meaning we deal with extraditions, with the European arrest warrant, but I wanted to include this topic as well, precisely because abduction in reality the abduction of minors, that is a type of case that then, where it manifests itself in the real world, it then generates three types of parallel situations. So it gives rise to a criminal proceeding, and often a civil proceeding runs in parallel, related to, child support, child custody, the child's placement, and so on. And then there's this third element, which is the repatriation procedure and the procedure that is provided for by the Hague Convention. I say this because while you are surely extremely well prepared, what often happens is that a client comes to the office and says, "Hey, my wife has taken our child to Spain, to Russia, to Japan. I'm going to report her." But we have to see if a criminal complaint is actually the right tool to achieve the desired results. For example, the return of the child to the home where they grew up. So, for this reason, even though it's a topic of private international law, I want to talk about it here because, in general, abduction also involves other types of interests, such as the protection of the child, respect for the national laws of both spouses. And so we can say that this convention, which is very old if you think about it, it's 40 years old, provides the main legal framework for resolving these disputes. It establishes the mechanisms for the return of the abducted child and the protection of the child's rights. So, the protection of the rights, of their rights, of the child. So, what are the origins and objectives? Later on, I'll also be using the framework, the Vademecum framework provided by the ministry itself, because as we'll see, each state manages the functioning of the convention through an authority called the Authority for Minors, our Authority for Minors, which regulates and governs the convention, is also physically located on Via Arenula at the Ministry of Justice. In fact, when you make these requests, that's how you learn the ministry's address. Via Arenula 70, because you find yourself writing to this entity, this body. The 1980 Hague Convention is therefore a multilateral treaty, and it was adopted to respond to this growing phenomenon of abductions, which can occur within Europe and very often outside of Europe. But what is the objective? I repeat, the objective is not to sanction the spouse, to have them arrested, or the main objective is to ensure the immediate return of minors who have been wrongfully removed or retained in another contracting state. So it's about repatriation. This convention is implemented not to convict the mother or father who abducted the minor, not to send them to jail, not to establish custody, but to physically take that minor and have them return to where they were. So, what are the fundamental principles to consider? One, the protection of the best interests of the child. Because the child, and pay attention, this is the fundamental rationale, has the right to maintain continuity in their family and social connections, just as they had them up until the moment they were abducted. So the second interest is the restoration of the original situation. Therefore, the convention aims to return the minor to the state of their habitual residence before the abduction. And then there is the principle of respect for, and let's say, compliance with international cooperation. That is, the member states, or rather, the states party to the 1980 Hague Convention, are obliged to cooperate with each other. But how exactly do they do it? Through these designated central authorities. So each country establishes a body called a central authority, which is always located at the Ministry of Justice in the capital of each country. The convention applies, please note, to minors under the age of 16. And so those among the are not covered, 16 years and 18 years, who were in fact illegally removed from their place of habitual residence, etc., etc. It is therefore important to get to the very concept of international subtraction. Abduction, by definition, occurs when a child is illegally taken from one parent or another, usually a grandparent, relative, friend, or lover, from one country to another without the consent of the other parent or the appropriate authorities. So be careful because subtraction can come through an action, therefore an activity, or even through a mission because abduction can also occur when a minor is held in another state, mind you, beyond the agreed term. And it often happens that, for example, the father or mother allows the child to be taken to see the grandparents. I don't know, in state X, they have to return by August 30th. The child doesn't return, and so failure to return results in omission, which is what essentially and fundamentally, concretely, international subtraction. What are the causes? The causes underlying international abduction, at least the main ones, are family conflicts, separations, and divorces. This is why I was telling you that the AIA procedure is the next step. The proceedings before the courts, in most cases, those involving minors or children, are probably parallel to the handling of a civil proceeding, namely separation or divorce. Other very frequent causes are cultural and legal differences between states. Very interesting. This is the case when it overlaps with the phenomenon of international subtraction, or at least cause it. For example, the perpetration of abuse or domestic violence. Although, as I was saying, the convention provides specific mechanisms for these situations, it is a highly civilized matter. I'd say it's quite superfluous to talk about it. Um, Pay close attention because one of the most important causes of international abduction is the attempt by a parent to change jurisdiction to obtain more favorable conditions in custody cases. I mean, I'll give you a classic example. Perhaps you've come across it. Two parents live in Italy. They plan to separate. And at a certain point, I don't know, the wife, for example, the wife runs off. She goes to Spain. She goes to Spain. And then 2 days later, she files for, separation, custody, and various other things. And so it's very important to understand that, let's say, this dynamic of attempting to change jurisdiction is one of the, let's say, triggers, one of the most important causal factors. It's pointless, let's say, to list the consequences in too much detail, but the consequences must nevertheless be remembered. I mean, the consequences for the minor, because the minor, and by the way, the judge called upon by the central authority to decide on the return will take this into account. But in general, let's say the convention pays particularly close and careful attention to the psychological and emotional difficulties, to the trauma stemming from the separation. Of course, it also considers the legal problems, the uncertainty related to custody, but also, because this is the point, the protection of the child's human, individual, and subjective heritage. There is extreme attention paid to the impact on the emotional stability and social development of the child. It's not uncommon, especially when, for example, one of the, let's say, parents comes from areas, perhaps in the third world, or in any case, with a lower standard of living than in Europe, While the convention also tends to shield the minor from problems with cultural and educational development. We've said that the convention establishes procedures for requesting repatriation, and this requests in general must always be made through, as we said before, the central authority. Every signatory state, therefore, for the minor, what is to be done? You must go to the central authority, you must turn to the central authority. In your case, if you have a client who reports that their spouse, partner, or whoever has taken away their child, you must contact the ministry on via arenula, because every signatory state of the Hague Convention, as we were saying, has a central authority responsible for receiving and managing repatriation requests. So the process typically involves, and you can also locate or find a complete set of forms on the official websites. If I'm not mistaken, you can usually find all the necessary information. In any case, the parent submits the request, which is a private and confidential request. The central authority will examine the documentation to verify the child's habitual residence and the wrongful removal itself, that is, whether it has actually occurred. At this point, the central authority will reach out to and contact the corresponding central authority of the state where the child is currently located. And in this way, we will begin the procedures for voluntary return, or if necessary, for legal action. That is, fundamentally, this convention aimed to create a network that would fundamentally help the parent whose child has been taken. But think about a case where this convention didn't exist. A child is abducted, taken to the United States. The father or mother is, I don't know, a factory worker from Vigevano. How could they, on their own, manage the recovery and repatriation of a child who is on the other side of the world? It would be completely impossible. This is precisely what the central authority is for, to step in and make appropriate use of legal prerogatives when necessary, as needed, by collaborating with and relying on the corresponding central authority in the state where the child was taken. One asks and always begins through, that is, the central authorities always prefer an initially amicable solution to the matter. That is, an invitation for the voluntary return or repatriation of the child. The judicial proceedings begin only when the voluntary return is not granted. And so, if it is not granted, a judicial proceeding is initiated, as I was saying, which is initiated by or begins with a particular process or event that sets everything in motion. The summoned central authority. For example, in a case where the child has been taken, I don't know, to America, well, at the request of the Italian Central Authority, the American Central Authority will initiate the judicial proceedings. So it won't be the parent from whom the minor was taken who has to initiate the process to file a lawsuit. No, it will be the central authority itself that starts this process. So once the judicial proceedings have begun, there will be an analysis of the unlawfulness of the removal, an assessment of any exceptions to repatriation, because obviously the parent summoned in that proceeding will always try to find a justification. So, a grave risk to the minor. These are usually the arguments that are used. Or many times the minor is manipulated to bring out the minor's own opposition if they are of a suitable age, for example, if it's a child who is maybe in elementary or middle school. Or many times the abducting party raises objections with details or reasons of a purely technical nature, like, for example, exceeding the 1 year time limit from the removal, and so on and so forth. What is international mediation? In some cases, international family mediation can be used to find precisely a consensual solution between the parents, avoiding long legal battles. But it's important, and I repeat, let me emphasize this point, to go back to the definition.